It's such a delight to have almost a crowd in this building, which is usually absolutely empty, and not because of our wishes, of course, but we are very proud to have a small institute still on site in Budapest, although the university has been effectively exiled forever to Vienna. And it is my delight to welcome you to our campus here in Budapest, which is still operational, although empty. My name is Dmitry Kochinov. I'm in charge of rule of law research over here. I'm a seconded person from Vienna, representing Vienna back home in Budapest. And what we do here, we try to give the rule of law a voice. So in fact, there is a small group of researchers focusing on the rule of law, including its impact on democracy in Hungary and elsewhere in the European Union. And we run a small clinic, which is called the Central European University Democracy Institute Rule of Law Clinic, supported by Stiftung Mercator. And one of the main tasks of the clinic is to intervene in front of the highest courts in Europe, especially the European Court of Human Rights. We have been, it's difficult to measure success if you just intervene, but we try to make sure that in the cases where all the emphasis is on human rights, we make sure that rule of law arguments don't get lost. And very often, when you make an emphasis on human rights, some fundamental rule of law issues they simply fall between the cracks. So in order to mark our presence, we organize public events. And last year, some of you probably attended the talk of Minister Bodnar, Minister of Justice of the Polish Republic, as he then was. And today, it's my absolute delight and pleasure to introduce an even more fitting speaker, given the aptness of the campus and given the subject matter of what we do over here as part of rule of law research. And that's Judge Artūrs Kučs, who now sits at the European Court of Human Rights. But of course, he has an extremely distinguished career as an academic and also as a judge elsewhere, including non-strictly speaking judicial bodies, such as the Venice Commission, where he was a substitute member for several years. He sat on the Constitutional Court of Latvia for almost a decade, which obviously allowed him to shape the law and to shape the future of one of the member states of the European Union. And now he moved upstairs, as it were. So the impact of his thinking has been amplified and has shaped our understanding of what Europe is about and the subject matter of today's talk, what judicial independence and the rule of law in Europe is about, especially in terms of how supranational and international courts can shape what we think about the rule of law. So, Judge Kučs, it's our overwhelming pleasure to welcome you here in Budapest. Thank you for coming.
Dear colleagues, dear ladies and gentlemen, first of all, I'd like to express my gratitude to the Democracy Institute and also to Dmitry Kochanov personally for invitation and organizing this timely event. I hope, as Dmitry said, the Institute is here and faculty is, I hope it's not forever there. I hope it will come back. I have a hope. And I would also like to forward to those of you who know sincere greetings from my esteemed colleague Andras Jakob, who also asked to send greetings to all the colleagues he knows in the Institute. And I think we just celebrated 75 years just a few days ago in a court, and it's anniversary of the convention, and we had a lot of speeches, solemn hearing. However, there was not a mood of birthday, I would say. In the speeches, I mean, there was a mood of marked by deep concerns about the rule of law, about human rights, about the future of the convention, about the court. And I would say the president of the PACE, Theodoros Rousopoulos, he went even so far as to make us to imagine the Europe without the convention, and what would mean for each of us, for our everyday lives. And something which many of us believe, still believe, which is impossible, is not, I would say, unrealistic anymore. However, I didn't came here to kind of paint everything gray. This is not my purpose, definitely, but rather to reflect what the court has done to protect the rule of law, judicial independence, discuss whether the court can do better, what academia, what the court, because in that sense I see academia and the court basically as allies. And I think academic environment is like this one is perfect for brainstorming, for discussion and constructive criticism of also the court's case law and court's activities. As Dmitry rightly said, I have an academic background focusing mostly on international human rights law, media law, but I should say that for almost last 10 years I have been mostly a judge also in a Latvian Constitutional Court and now a bit more than a year in Strasbourg Court. So my approach would be also in my presentation mostly empirical rather than based on any theory-based models which you normally would expect in academia. So I would like to focus in my presentation on recent and current challenges for the independence of judiciary, for what it means basically for democracy and rule of law in Europe, how the Strasbourg Court has responded to these challenges through its case law, including the success but also criticism of the court jurisprudence, and also questions which are open in the air, let's say, and also limits what one can expect from the court, because sometimes I would say we have a very far-reaching expectations from the court, but there are also limits what the court can do. Furthermore, I would not address that in my presentation, but during the discussions, it's kind of my interest if there are any views among academics, related to also some of the issues which go to the core of democracy, basically free elections, and also how far the court should or could intervene into that. It's a question also which is perceived by some countries to be an exclusive competence of the parliament. So namely, I would mention two examples which has been recently. One is from Strasbourg Court, one is from national courts. Basically, how far national courts or courts in general should intervene when we talk about election meddling, about disinformation campaigns. There has been an example of Romanian Constitutional Court, which has been, I would think, controversially discussed whether the court is not taking powers of people and free election and annulling the results of the first round of presidential elections. And from Strasbourg perspective, there is one small step, but also is a recent judgment of Bradshaw versus United Kingdom, where the Strasbourg court, I would say for the first time, said that under Article 3, Protocol 1, right to stand free elections, it's not only from individual perspective, but it might have more further reaching obligations to states, positive obligations of the states to investigate election distortion, disinformation. So these are, I would say, just points for another point I think we might raise for discussion if there will be, because I think these type of, with social media and artificial intelligence on the top, I think these type of situations will be more and more. And then it's a question also of very often how far the court should be part of all of this. But coming back to my judicial independence, I would say for me as a former judge of Constitutional Court and also now judge in Strasbourg Court, judicial independence is, of course, is personally also special value, and it's crucial for us judges to perform our task impartially and objectively and play the role individuals and society can legitimately expect from judiciary in a democratic society. Judicial independence, therefore, of course, it's not only I wouldn't say it's not a privilege for a judge. It's a right belonging to every citizen. try to have their disputes resolved by tribunal which is free from pressure, fear, or favor. And I have to admit that I probably have been lucky enough to have my decisions made freely while I was a judge in constitutional courts. And the only pressure I had within my mandate as a judge of constitutional court, I would say probably from groups of the society, especially when we adopted in constitutional court the so-called decision on LGBT rights, basically imposing an obligation for parliament to create a legal framework for LGBT persons to be able to recognize their legal status. And that was actually before Fedotova. After Fedotova, you could easily say that such obligation today is also coming from ECHR case law. But the fact that part of the society harshly or strongly criticize you, that's part of our job. And that's, I mean, something I think as a judges, we should be accept and should be prepared for. But questions during, of course, these years in constitutional courts, you had a number of meetings with colleagues in different countries. So there were a number of questions which have been foreign to my experience. For example, also when the questions asked, what kind of procedure do you have in a country if the judgment of constitutional court is not implemented? I would say we don't have that in Latvia, because this so far has not been a question. I've never thought in such terms what kind of procedure do you need if decisions, judgments of court are not implemented. But of course, I would say these things are not carved in stone. And also in my country, these things can change. And I would say some recent debates, which as you all know, including about Istanbul Convention, which is now suspended for a year. So it's not carved in stone, and things can change, of course, unfortunately. Therefore, looking also more broadly in what is going on in a continent, in Europe, and recently we have seen a number, of course, of attacks on independence of judiciary, both at the domestic level, but I would say also the pressure on the Strasbourg court itself. I think all of you know about the famous letter of 7 governments. Nowadays, we don't even know if it's a 7 or even if it's more than 7, about the need of court to change, I think, the practice in a migration field, so which is, I would say, direct kind of attack on the court's independence. Changes of another, I mean, examples have been changes of the court's composition, powers of procedures of appointment, dismissal of judges, and I would say similar measures which academics usually call packing of the courts. So basically packing of the courts in order they become an instrument of the called managed democracy. So this has been a common practice in some Council of Europe member states. And what has been, I would say, over last years, I mean, especially worries that this is not an individual case. We can see in a number of states this has been a systemic failure, systemic practice. With judicial independence in the country necessitating the court occasionally to adopt a pilot judgments procedure, like it was Walesa versus Poland, which is still under implementation, or to refer not only to violations of right to fair trial, but also even to Article 18 of the Convention. So basically, that far-reaching aims of these measures. I mean, what happens when the courts are captured, I think, as academics, you know better than me. I mean, history has showed us that this is a road to authoritarianism. It's not usually only attacks on judicial independence. It's silencing opposition, silencing media, silencing journalists. This is usually a concerted action. And therefore, I would say an independent judiciary ensures citizens that they can challenge government actions, that minorities can seek protections, that elections have any meaning, basically. And the court has said a number of times the rule of law and judicial independence are a precondition for democratic society. So let me briefly, I would say, proceed how the court has responded to recent challenges and how basically it evolves this protection of judicial protection of judicial independence. And the key is, of course, in a convention is Article 6, that everybody who is entitled to fair trial by independent and impartial tribunal established by law. And this has been, I would say, become a constitutional anchor of judicial independence across Europe, this Article 6. And I would say that historically, as I think most of you know, Article 6 may mostly apply to parties when they go to the courts, but then they can challenge different procedural rules, independence, impartial, but it did not protect the judge as such, whether he can use Article 6 in order to protect his own rights if the executive, also authorities in a state basically attacked the independence of the court. And then the first case I would like to refer to is, not because we are also in this country, but I think I think I see the offsprings in this case. But while I was not in, as I said, it's always a different picture when you are in a case. But I can only see the case from outside because I'm a bit more than a year in a. It's a case of Bacca versus Hungary. It's also we are in a country, but I think I saw the offsprings of this later jurisprudence of the Strasbourg court already in Bacca versus Hungary, which to me is the foundational judgment concerning the subsequent rule of law and independence of judiciary. Case law of the court, which emphasizes the right and even a duty also, not about from also perspective of Article 6, but also Article 10 of the right and duty of judges to speak out against political reforms aimed to suppress the independence of judiciary. And under Article 10, Mr. Bacca, in that case, I mean, when he complained that his mandate as the president of the Supreme Court after so-called constitutional reforms in Hungary had been terminated as a result of his critical views he had expressed publicly in his capacity of the president of the Supreme Court on constitutional and legislative reforms affecting judiciary. While I guess we would all agree that judges, due to their function, should expect to have self-restraints regarding public expressions. And this is actually one of the issues currently before the Grand Chamber in case of Danilec versus Romania. So we'll hope we will see very soon, but it's a broader expression where judges expresses not only about judicial reforms, but mostly about political situation in the country. This has been decided by Chamber, I think 4-3, so it's, as I said, in front of Grand Chamber now. But the court has been very firm that this is different when expressions directly concern legislative reforms affecting judiciary. In these type of cases, especially, I would say, if you are a president of the Supreme Court, you are not only allowed, but you are obliged, I think, to speak out. So, and the court had stated that the questions concerning the functioning of the justice system fall within the public interest. The debate of which generally enjoys high degree of protection under Article 10. And even if an issue under debate has political implications, this is not in itself sufficient to prevent a judge from making a statement on a matter. And the Grand Chamber in Bacca, so the court concluded, I think, violation of Article 10 in this case. So, but the Grand Chamber in Baca case also dealt with the inability of Mr. Baca to contest the premature termination of his mandate and found also a violation of the right to fair trial. This is not the case where the court already have accepted the freestanding right for judges to protect them against interference with independence. So that's happened later. I will come to famous Icelandic case, which I guess you all know. But it still found a violation of Article 6 since the applicant had not been able to challenge his removal in a court. And this was possible because the court held that the applicant himself had a civil right to protection against his removal, despite the fact that as a court president, he was exercising state authority. I think, as I said, I found this judgment already as a landmark judgment, which was a basis later for the court subsequently to expand on Article 6 and create a subjective right for judges to have their individual independence safeguarded and respected by the state. However, at that time, I hope it's now anchored in a convention, we will not go back, but at that time, it was not so clear-cut. There were also critics among the courts, and the most obvious critic was judge elected in respect of Poland, Judge Wojtycek. We can just discuss whether he knew what will come afterwards or whether he would have done it anyway, but he basically, and I quote, he questions that applying of Article 6 towards judges, and basically saying that legal rules pertaining to judicial independence are interpreted in a manner which seems to transform them into special human rights granted to judges. In this way, the court has extended its jurisdiction to certain public law disputes between state organs. That's the way they see it. He sees it as a dispute between state organs where human rights has nothing to do. So, because these are two, I mean, by trying to characterize them as human rights disputes. This is a major change in European paradigm of human rights protection and a challenge to European legal tradition. And I'm concerned that this approach, consisting in tacitly recognizing human rights as state organs, may, in a long-term perspective, undermine the efficiency of human rights protection in Europe. That's a quote from Judge Wojtycek's dissenting opinion. He was not the only one, but he was probably, to my view, the most visible one in a sense. However, I would say, again, referring to my esteemed colleague Anja Seibert-4, who's a judge elected also in respect of Germany, that that governments can't rely on special trust and loyalty that the judge owes to the state for the purpose of excluding the protection of Article 6. Such a loyalty is not owed to authorities, but to the rule of law and democracy. And it's in the interest of upholding the rule of law and giving effect to conventions that judges must be able to challenge in court interferences with their independence and impartiality. So, but this view, of course, has been echoed by many judges, including the former President Spano. So, but as I said, it was not, how to say, straightforward, at least at that time. Now I think it's clearly anchored in a Strasbourg case law and also in a case law of Court of Justice of the European Union, but it was not so clear-cut when it started. However, it was not until Grand Chamber judgment in I hope I will pronounce, but Hungarian might be closer to Icelandic, but Guðmundur Andri Astradsson, I hope, Astradsson case versus Iceland, where court established that Article 6 includes a freestanding right for judges to protect them against the interference with the independence. And where the court also, for the first time, set the clear principles for assessing legality of judicial appointments under Article 6. So in that case, there were reforms in the country. The new appeal court was basically established. There were 15 judges who were to be appointed. There was independent evaluation committee, which basically ranked who should be appointed how. And then the minister, before sending a list to parliament, changed the sequence. So apparently, there are different motives, but basically it was arbitrary decision of the minister. And parliament approved this by vote. And when Mr. Artūrs, who was tried for, I think it was a drunk driving or something, so traffic offense. So he said, yeah, but one of the judges, which is in composition, it's not established by law because he is approved in a procedure which was not prescribed by law. And in this case, the Strasbourg court, the gun chamber explains that guarantee of judicial independence is linked to requirements the courts must be established by law. And Strasbourg court held that the object of this term to be established by law is to ensure that judicial organization in a democratic society does not depend on the discretion of the executive. In this case, as I said, discretion of the minister. But it's regulated by law emanating from parliament. The court also established a 3-step test in this case that to decide whether defect in an appointment procedure of a judge leads to violation of Article 6, if it's manifestly breach of domestic law, and if it affects ability of judiciary to perform its duties free of undue interference. In this assessment, the court has also regard to the manner how national courts have reviewed the alleged irregularity and its consequences. The court also, Strasbourg court also criticized the justice minister in violation, that in this case, basically, the court has been composed, including one judge, but you don't have to even decide what others would have decided, but it's enough that one judge in composition was, as I said, not established by law, that the Minister of Justice has voluntarily, arbitrarily changed the composition, which was approved by Parliament without kind of providing any reasons. And this judgment has become a leading precedent for dealing with executive interferences in judicial appointments. And I will come in a minute to a number of Polish cases, but however, at this point, I would want to raise a point for discussion, if we may. So if you look at the Artūrs test, so basically, there was an interference by executive, that's one thing. It was contrary to the domestic law itself, the second. However, my question would be more broadly when the interference is done according to national law. It's not against, and it's not done by executive, by parliament. And whether the courts can intervene, how far they can intervene. And I'll give you an example from my own country. As I said, it's, within the 7 years, I have never experienced any kind of pressure from judiciary, from executive, on other powers. But it's always a question what you do afterwards, might be. So in our system, we are parliamentary republic, and that's like in many. So the major decisions, basically judges, the procedure is that you have to go through judicial council, but if you are Supreme Court judge, you will be appointed by parliament. The parliament is who is the one who says the last word. And the former chair of the Constitutional Court, with whom I had with whom I served together, she, after her term expired, she went to to the stand as a nominee for the Supreme Court, because that's, according to Latvian system, might sound strange for some of you, but even if you have been a judge of Constitutional Court, if you later want to go to Supreme Court to become a judge of general courts, you still have to go through a procedure. So she went through judicial councils, there were no objections, but then the parliament, by narrow majority, decided not to appoint her, without giving any reasons. The procedure is according to domestic law. It's decided by parliament, not by who is the highest body in our country. It's not executive. So, and the parliament stated no reasons. So there are speculations that this might be due to her stance in LGBT case when she was the president of the court, but it's only speculations. There are no arguments, I would say, open arguments. So she was later, I mean, the story is, I would say, has a happy end, if I could say so. She was appointed later, but by another parliament, so she had to wait a change in elections. But my question is, and this has been raised to some degree also by the recent judgment of Misiūnas versus Lithuania, where there was a president who decided not to proceed with appointment of the judge, because in Lithuania it's a power of the president also to appoint a judge. Should the courts actually intervene in such type of cases? Because the procedure is according to the national law. It's not a violation of domestic law. It's done by parliament, by highest body. And can the courts intervene? Wouldn't that be against the separation of powers? Because, I mean, would that be a judicial, I would say, self-defense, or as some academics argue, judicial self-dealing and would counter to legitimate powers of parliament and free mandate of parliamentarians? So it's mostly, I would say, for those of you who are constitutional lawyers, and I think an interesting debate. And if yes, how far the court should intervene? Should they only look at the procedural scope of the issue, or should they also go to the merits and the essence? That's another issue. In Latvian constitutional law, we do have a principle so-called of good legislation. But that's concerning our national legal system, which was also contested by some judges, but still, I would say this doctrine is there, that in line with this principle, the parliament should not only follow formal procedures, that's when it's deciding about restrictions on fundamental rights. So it's, for example, by formal procedures, I mean, if you have 3 readings for the draft, or that you have 3 readings and not 2, you don't do it in 2 readings. But also that Parliament should provide reasons for the decisions when they decide about limitations of fundamental rights. So in order, there is a debate, there are arguments, and the parliamentarians are aware of these implications of their decisions to limitations of fundamental rights. So this is a principle we have in our national constitutional doctrine. As I said, not everybody is in line. It's a normal process. Normal, you wouldn't expect I think in any constitutional court that everybody would agree. If everybody agrees, I mean, then it's a sign of, yeah, because usually we have independent personalities and different views. So, but for obvious reasons, in Strasbourg as an institution, as an international court, this principle doesn't exist, but you can find, of course, I think, elements or traces in some judgments where because national constitutional legal systems differ. Some are presidential, some are parliamentary, so there is wide variety. So that's why I would say it wouldn't be for the international court to go so far, but you can see some elements in assessing the necessity of restrictions in a debate. Also, that the court looks on the quality of the debate about limitations in a parliament. For example, one example would be animal defenders case, or also a recent judgment which was basically said that it was not debated in a parliament, but was adopted by executive, Venice versus Estonia, also quite controversial, in a case controversial in the sense 4-3 judgment about the ban on smoking total ban on smoking in prisons. So there are some elements we can see in Strasbourg, but of course it's first and foremost for the national courts, national constitutional, national supreme courts. So yes, how far the courts can intervene if it's, as I said, it's according to domestic law, at least if you look formally to the domestic law, it again depends, and what is the scope of the court's review. Some cases from Poland and just looking also at timeline, that's the court directly applied Artūrs test in famous EChR case versus Poland, where I think it was first time the Strasbourg court said that the whole constitutional court tribunal is not established by law. That was something unprecedented so far, and because I mean there were judges appointed to a seat already filled lawfully by another judge. In clear breach of Poland's own Constitutional Court Act. Therefore, I mean, there was a manifest breach of domestic law, breach of which concerned fundamental rule ensuring independence of judiciary, and basically you had no remedies against against the composition of the tribunal, which decided your issue. So the court found a violation of Article 6.1. I will skip some, and now my last one which also illustrates, I would say, not individual but systemic flaws in judicial appointments, how that contaminate individual trials. It's a case of Venice versus Poland, where the court adopted a pilot judgment procedure. In this case, former president of Poland, Lech Walesa, he challenged in domestic court judgments that confirmed that he had collaborated with communist security services. His appeal was reviewed by Chamber of Extraordinary Review and Public Affairs of the Polish Supreme Court. The chamber, which was appointed on recommendation of the new National Council of Judiciary, whose independence from executive and legislature had been seriously compromised. And in this case, the court basically found a number of arguments to find that there was no independent and impartial tribunal established by law, and there was also a breach of Article 8 private life, which I will not go to. But the court basically said that there is a systemic defect in appointments, because National Judicial Council was already found by both Polish and EU bodies to be subject to political influence. The court also applied Artūrs and EChR principles, and holding that the tribunal was not established by law. So, of course, the number of, again, I will come back to at the end, I mean, we have a pilot judgment procedure, but we all know, and the next question is implementation. The court mentioned a number of deficiencies in the Polish system regarding to National Judicial Council, how that can be changed. I mean, then also how we are dealing with judges which are appointed through deficient procedures. So I'm just thinking it's 3 weeks ago, I think, or 4 weeks ago, we were in a conference, and a number of us of judges in administrative court of Supreme Administrative Court of Poland, where I would say it was an anniversary event in a sense. And normally in anniversary events, I would expect kind of speeches related to anniversary, but the representative of the president of Poland was quite direct. I have never seen such a direct text in an international in event, basically saying quite clear that Article 6 applies equally, which is true. I mean, in a sense, it should apply equally, but it's a question, if you go to the roots, it should apply equally to all judges, and also the judges which were previously appointed by these procedures. Their independence, impartiality should also be equally regarded and safeguarded. So this is a very clear message without any connotations. So these judgments in the Polish cases also illustrate, I would say, a systemic problem of the independence of judiciary at domestic level, which affects not only rule of law in Poland or in a specific member state, but it of course affects effective application of the convention and the work of the court. Because, as you all know, under the principle of subsidiarity, the national courts are the primary ones to apply Strasbourg case law, to apply, to ensure fundamental rights, and only if they fail, international court should intervene. We should not be the primary ones. But the whole system, I would say, is based on this, on this dialogue and cooperation between the Strasbourg court and national courts. However, when the national courts cannot be regarded as a tribunal established by law, and Strasbourg becomes the first and only safety net for individuals, that's, I think, the whole idea, the whole system, becomes difficult, complicated. I mean, there are many, just from my experience also as a single judge in some issues, I mean, there are issues where you can clearly see where you can balance, I mean, if it's Article 10, but if it's Article 6 procedural guarantees, it's very difficult for me as an international judge to go to the courtroom in a national, say, if the applicant has been really heard, if his views have been discussed, I mean, if he has been allowed so it's first and foremost national courts. And so if you have systemic flaws in a system, it has a very wide-ranging implications for the whole system, how the Strasbourg court can work. And that's why in this case, the court has been quite clear that certain courts in Poland we cannot anymore take as granted, rely on them. And this has not only been Strasbourg's, but I would say also Luxembourg court's stance. The court's evolving case law under Article 6 to protect independence of judiciary has been, as I said, subject to some criticism. It's from both sides. Number of academics, number of judges have criticized the court for, I would say, for judicial activism and replacing democracy in the name of defending it by extending this Article 6 to judicial appointments, thus allegedly interfering in power balance between different state organs. In the case of Baka, criticism has been also linked that Hungary adopted these reforms through constitutional reform, so these were not ordinary laws, but constitutional laws, which has a strong special procedure and stronger legitimacy. And again, I will quote Judge Wojtycek, former judge for Poland, who said, under such an approach adopted in the instant case as the most important expression of popular sovereignty, because it's namely the national constitution, would not be subject to scrutiny under a convention by an international court. Moreover, this scrutiny extends to the actual motives to constitutional reforms, and the present judgment is an important step towards substantially limiting constitutional autonomy of high contracting parties. So, but I mean, this has not been, I mean, that's a more broader question, of course, but for me, I think constitution should not be a safeguard if you violate the convention by the constitution. There has been a number of other cases not related to judicial independence, where I think constitution should not stop the court to recognize violation if there is a violation of the convention. It's up to national courts then, or national authorities basically, also parliament. For example, a neighboring state, Lithuania, has also changed the constitution after famous Paksas versus Lithuania judgment. So, and it happened. So it took time, but it happened. However, I would say from our opposite side, there are views expressed, I think the majority of judges and also in academia, that the real danger is not judicial activism, but judicial silence in the face of democratic decline. And also as a former President Spano has emphasized, passivity in the face of democratic backsliding would betray the convention spirit. Some judges have criticized also Artūrs for going too far. So basically for not explicitly endorsing standards adopted by Venice Commission to require the judicial appointment be controlled by bodies with a majority of judges. So I would say I tend to see more support and extent, but there are also critical voices. So nowadays, you know, in this world of bubbles, it's important to see both sides, and because sometimes if we are in social media, we don't see the other side picture. So to conclude, I would say the court has succeeded, and I would say by protecting, I think, especially if you look at the Polish case, I mean, in different aspects of personal and institutional judicial independence. These aspects are now integrated, I hope firmly within Article 6 of Convention, which empowered also national courts in Poland to resist judicial reforms, so-called judicial reforms. The court has also decided to relatively speedy some of the subsequent cases because, I mean, time is also another factor. And instead of individual approach, I mean, court has also taken, Strasbourg Court, pilot judgments and also indicated systemic problems in a specific country. So requiring for further general measures. However, this has not been, shouldn't say it's only Strasbourg alone. We could see this has been, I think, one of the few but very illustrative example of concerted action of both Strasbourg Court and also Luxembourg Court, not to mention Venice Commission and other institutions. And I would say it's true that one can't expect the court alone to prevent the erosion of democracy and judicial independence. Other political bodies of Council of Europe member states, including Committee of Ministers, who has a special responsibility to ensure compliance of states with the court's rulings, and have should play its role. Because, of course, the attacks on democracy, attacks on judiciary in one member state, they spill over. They usually don't stay within one country. I would say by concluding that the justice is strong not when it's easy. Justice is strong when it's difficult. That's actually the test for the judiciary. And as a former president of Italian Constitutional Court, Marta Cantabria has put it we had a discussion in our court. She said that human rights, democracy, and rule of law were self-evident values after Second World War. Unfortunately, they are not today. Therefore, the importance of the institutions, I would say, including independent courts, but also academia, because we see not only courts are attacked, but also universities in many states are attacked. The importance of these institutions to protect these values, I think, is more important than ever. Thank you.